Hi, I'm Margaret Robb. I'm Chief Judge of the Indiana Court of Appeals, and I'm here today to talk about professionalism and collegiality in the appellate process.
And Judge Robb, you talk about some of the mistakes that people should avoid. First on your list deals with knowing the appellate rules.
Yeah, nothing will get you into trouble sooner than not knowing the appellate rules. If you're going to do an appeal, you really should read them very carefully, particularly because they are now changing, and there are a number of things that are brand new for 2012. So even if you're an experienced appellate attorney, I would urge you to read and reread them.
And another mistake you talk about is asking for extra pages.
Yes, we are a busy court. We write about 2,500 appeals a year with full opinions. That means every chamber is writing about 160 cases a year and voting on another 320 to 350. So that means every time you ask for more pages, we read more pages. So my suggestion is get an eraser, learn to edit, maybe even have someone else read your brief to help you decide what really isn't necessary, and focus on the things that are important for us to know for your appeal. We don't often need to know all the facts of your case or everything that happened in your case if it has nothing to do with the issue that you're taking or the issues that you're taking on appeal. And that's often a very easy way to limit pages.
And is accuracy important?
Oh, yes, accuracy. Lots of different aspects of accuracy. Accuracy in the law, I would suggest reading more than just the head notes, because sometimes that really isn't what the case is all about in its fine-tuning. Accuracy in the facts, accuracy in what's happened, accuracy in the things that relate to your appeal. All of those things are important because your credibility is really what's on the line. And when we start finding errors in any one of those things, it really causes us to look very carefully at everything else you've done. And what you really want us to do is start reading your brief and sort of shaking our head, why yes, why yes, why yes, and getting to the end and saying, why yes. You don't want us to look and go, I don't think that's what really happened. So accuracy is absolutely critical.
How do you feel about terms like hereinafter, pursuant to, herein?
We all speak English, and there's no reason that your briefs can't be in English. Latin is very nice, and there are times when you need to use Latin. I think we probably still use the terms per stirpes, and we all know what that means, but a lot of things don't have to be in Latin. There is a good old plain ordinary English, and it usually works. So, yes.
And is it important to cite to pertinent case law?
As I mentioned with accuracy, yes, it is important. String cites are not necessarily important, and it may be that on a particular subject there are lots of different cases. It's probably more important to pick a case that really does focus in on what you want to say. I might note, while we still give case numbers district assignments, the districts really don't mean anything anymore. So the fact that your case might have, say, a second district case number on it doesn't mean that cases that have a second district origin aren't necessarily more important or more meaningful. So that's sort of something you can ignore, but you do want to be sure that you're being both accurate and citing the precedent that really will take your case.
And do you think professionalism includes civility?
Absolutely. If you look at seasoned attorneys, they are very professional, they are very collegial. We don't particularly find any humor or interest or even appreciate when you take jabs at opposing counsel, when you take jabs at the trial court. Most of these judges we know and we respect. And we certainly don't find it amusing when you take jabs at us. It is often interesting that you will make those kinds of comments about us. We're the very court you want to rule in your favor. So it is important that you be professional, that there's ways of saying somebody got it wrong. In fact, that's really one of the things that makes rehearing briefs so difficult. You're going back to the very court that just ruled against you and pointing out why they made a mistake. So it's really very possible to do it professionally. You obviously don't like what the trial court did, or you wouldn't be appealing it. But you don't have to call them names, you don't have to denigrate them, and you certainly don't have to do that for opposing counsel. If your arguments are well-founded, there's just no place for that.
Is it important to know the weaknesses of your case, or is it better to just overstate your strengths?
Well, it is important, obviously, because no case is perfect. Every case is going to have strong points and weak points. And if you don't do that, you miss a lot of opportunities. You're going to have cases that you have to deal with that don't work for you. You're far better off in your briefs right up front, either trying to distinguish the case, trying to say why it is different than your case, why it doesn't control your case, because you have to assume the other side is going to address that case. And many times you can look at the facts, look at the history of the other case, and say that while it would appear at first blush that it does impact your case negatively, it really doesn't, and then proceed to set out why. Because I can tell you that the last thing you want is for us to do it in an opinion and say, you didn't cite a case that's on all fours against you, and then have to show that opinion to your client. Oh, whoops. So it is important, and I think it's something that you can, what's the old adage, take lemons and make it into lemonade, and that's really what will help your ultimate conclusion.
Not every case goes to oral argument, but when a case does go to oral argument and you ask a counsel a question, what are you hoping for?
We're hoping to have our question answered. You will come to an oral argument with your planned speech, and I can assure you that about 30 seconds into your planned speech, that might be about as far into your speech as you're going to get. And a good appellate advocate will use that as an opportunity. We're asking questions that we're having problems with. And so if you try to stick to just what your speech is, you're going to lose the opportunity to have a really meaningful conversation with us and to listen to the things that we are concerned about. Because after all, we're going to be writing the opinion, and it's your opportunity to fill in the blanks. I might add that we don't do very many oral arguments, and so if you want one, you need to ask for it, although we do choose oral arguments on our own, but you have a much better chance of getting an oral argument if you ask for it. But don't just ask for it. Give us an idea why that additional conversation is important. There is the old adage that if the briefs are really good, we don't need the oral argument, and the briefs are bad, we don't want them. But that's really not true. There are a lot of cases. Sometimes it's a case of first impression. Sometimes it's a case where the facts are very confusing. Sometimes it's a case that maybe we haven't dealt with for a very long time, and times have changed, and maybe some of the law that we relied on has changed. So there are lots of reasons why we want to have oral arguments, and obviously people get them. So spell out why you think this is a case that warrants us having that conversation. And that's really what an ideal oral argument is. It's a conversation with the three judges and the lawyers.
In many briefs, it seems like the statement of the case and the statement of the facts end up looking exactly the same. Can you talk about how those should be different?
Absolutely. There are times when they will be the same, and that might be a strictly procedural issue that you think something didn't happen correctly. But when it's not a strictly procedural question, the statement of the case is really just those things that happened in the case that we need to understand to know how we got to where the issues arose. The statement of the facts are those pertinent facts that relate to your issue. As I said before, not every fact is necessarily something we need to know about. And you also need to know the trial rules will say exactly how those facts have to be provided. They have to be provided that are favorable to the decision of the court. So if you look at the facts, there is nothing wrong with saying additional facts will be provided as we get to the argument. But the facts ought to be those facts that we need to know about in order to decide the case. And that really is very different from the historical perspective of how we got where we were.
And then finally, you are Chief Judge of the Indiana Court of Appeals. Have you had any cases where you felt like people didn't understand they were in the Court of Appeals, thought they were in the trial court, or thought they were in the Supreme Court?
And that's an important point. When you're taking an argument to our court, your trial brief is not going to be persuasive to us. We are an appellate court. We are an error-correcting court. We are not the Supreme Court, which is a jurisprudential court. So you really need to table your argument for us. Now, there will be times when you just want the law to be changed, and we're not going to be able to change it. But you still have to be able to tailor your arguments, knowing that we are an error-correcting court and we are looking at what the existing law is. But it is a good stage in which you can talk about why the law needs to be changed. We may not be able to rule in your favor, but we might be able to say you make a really good point, and the Supreme Court or the legislature, if it's a legislative issue, needs to take a look at that. What you really want is for us to tee it up if the issue is one for the legislature or if it's an issue for the Supreme Court. You're then in a better position to go to the Supreme Court and say to them, here's why we think the law needs to be changed. But arguing to us strictly that the law needs to be changed may well be the answer, but we can't do it.
Thank you very much for your time today.
Thank you, and good luck to all of you.